Imagine this is you, a young, talented, and enthusiastic employee. After years and years of dedication and commitment, working days and nights, you yet find a major leap in your career. One day, an idea came to your mind, and you together with your team are now turning it into an invention. You hold a firm belief that the invention is going to mark a milestone in your life and your company's performance. Now, before getting extremely excited with the launching of the new invention, you get troubled with a big issue. How can you get the invention protected? As a patent or a trade secret? Well, before making a final decision, you might want to distinguish between these two and weigh their advantages and disadvantages. First, let's take a look at the overall definition of these two concepts. According to Article 4 of Vietnam's Intellectual Property Rights 2005, patent is a technical solution in the form of a product or process aimed at solving a specified problem. Meanwhile, trade secret is information obtained from financial and intellectual investment activities that has not been disclosed and is capable of being used in business. When you're wondering choosing between patent and trade secret, you need to know what is the eligible subject matter of each one. While the subject of patent generally is related to technical information, the coverage of trade secret is much broader, with other aspects such as industrial processes, strategic plan, customer data, and so on. Famous examples of trade secrets could be KFC Chicken's recipe, Coca-Cola's formula, or Google's algorithm. Having identified your subject matter, you need to know whether it meets the condition for protection. An invention needs to be new, creative, and capable of mass production in order to be granted a patent. Meanwhile, a trade secret is protected if it's not common sense and not easily obtained, giving the holder an economic advantage. Besides, it should also be kept confidential, so that it shall neither be disclosed nor easily accessible. Trade secrets will be lost once the information is no longer kept secret, but will theoretically last forever if it never loses its secrecy. In contrast, patent protection operates on the public disclosure of information regarding the invention. If the inventor refrains from describing or revealing important details, a patent will be invalidated. Regarding disclosure issue, two relevant questions are worth considering. First, is the asset in question commercially valuable and worth keeping secret? If keeping certain information secret gives your company a competitive edge and added economic value, you might want to consider trade secret protection. Secondly, is it easy to reverse engineer your invention? If people could independently invent or reverse engineer your work, consider publicizing your invention and have it protected under a patent. Trade secrets do not protect you and your invention from this act. Secondly, we'll have a look at the ownership of these two concepts. Owners of patents are organizations or individuals that are granted protection titles by a competent authority. Patent owners can be the author of the invention, the inventor, or another entity like a person, a company who has been assigned the patent rights. For example, before being admitted into the company, you have signed an invention assignment agreement. Then, having innovated a new invention and had it patented, you are the inventor, but your company or your employer would be the lawful owner of the patent. Note that patent owners are the ones to enjoy all the rights, titles, and the interest granted by the patent, not the inventor. Owner of a trade secret is an organization or individual that legally obtains a trade secret and keeps it confidential. In reality, trade secrets are usually owned by the company, the employers, or the hiring parties, even if they are generated by the employees, unless otherwise agreed by the parties involved. For instance, the 7X recipe of Coca-Cola, even though having been created and guarded by its exclusive staff, it's owned by Coca-Cola itself the entire time. A trade secret owner is only obliged to take measures to keep their trade secrets confidential. These measures can be taken as locking doors and having robust IT protection, or maybe keeping papers off desk when visitors are all in the area. Let's come back to the 7X recipe example of Coca-Cola. The recipe is currently kept in a vault at the Bank of Alaska, and those who know the recipe have signed a contract to keep it secret. Meanwhile, a patent owner is obliged to use the patent, pay annual fee, and give the inventor or creator a reasonable remuneration based on the extent that the invention is applied and the economic benefits it yields. So if you're willing to pay an amount of money to protect your business invention, or you simply want to give or receive any reward from your organization or individual invention, you had better register for a patent. Patent shall confer on its owner a right to prevent third parties not having the owner's consent from the acts of making, using, offering for sale, selling, or importing for these purposes that product. patent owners also have the right to assign or transfer by succession the patent and to conclude licensing contracts. Therefore, once registering the patent for your business invention, you do not have to worry about others using your business intellectual assets illegally without paying you a cent because your patent is protected upon the law. Trade secret protection confers owners the right to prevent the information lawfully within their control from being disclosed, acquired, or used by others, without their consent in a manner contrary to honest commercial practice.
Another very important question you may want to ask is whether someone is making use of your trade secret or patent. To answer this, you need to get to know about trade secret and patent infringement. Trade secret infringement is called misappropriation. It occurs when someone improperly acquires a trade secret or improperly discloses or uses a trade secret without consent, or with having reason to know that knowledge of the trade secret was acquired through a mistake or accident. Misappropriation need not to be intentional. It can happen inadvertently or through negligence. What counts as improperly acquiring a trade secret? Breaches of non-disclosure agreement, industrial espionage, theft, fraud, and bribery are all improper means of acquiring a trade secret. For example, if you hack into a company's computer and copy the file, this act of acquiring the secret improperly is misappropriation. If you are asked to sign a non-disclosure agreement that states you can only work on secret information on company computers, and you log in to do some work on your unsecured private laptop in a public place one weekend, this may also be considered misappropriation. Are there any cases where misappropriation can occur? Misappropriation can occur when someone discloses or uses a trade secret without consent, when, at the time of disclosure, he or she had reason to know that knowledge of the trade secret was derived from someone who obtained it through improper means, obtained under circumstances that gave rise to maintain its secrecy or limit its use, or derived through a person who owed a duty of confidentiality to the trade secret owner. For example, if you run an online website and an employee of a major corporation breaches the non-disclosure agreement to give you the corporation the trade secret formula for a popular soft drink, you may be liable if you publish the formula or having facts that suggest the employee breached the non-disclosure agreement. Now, let's see how patent infringement occurs. Vietnam applies the doctrine of equivalent infringement and literal infringement. Therefore, patent infringement can take any of the following forms: a product or part of a product that is identical or equivalent to a product or part of a product within the scope of protection of an invention patent, a process that is identical or equivalent to a process that is protected as an invention, a product or part of a product that is manufactured by a process that is identical or equivalent to a process protected as an invention. Vietnam IP law also sheds further light on the criteria to assess equivalent infringement. To qualify as equivalent infringement, the two technical features must be of a similar nature or substitutable, substantially share the same purpose of use, substantially share the same method to achieve the purpose of use. In practice, most patent infringement cases in Vietnam involve literal infringement. Therefore, the courts in Vietnam have not had much practice applying the law on equivalent infringement. In order to better differentiate patent and trade secrets, registration for protection also needs to be further clarified. For the registration procedure, in Vietnam, you don't have to register your secret with any governmental body to qualify for trade secret protection. On the other hand, if you want to obtain a patent, registration is required. You have to file your patent at the National Office of Intellectual Property and go through a lengthy examination for months. Therefore, in theory, the cost to obtain a patent is more expensive than that of a trade secret because it includes expenses such as application fee, protective certificate fee, maintenance fee, and renewable fee, etc. However, in reality, the cost to maintain a trade secret is also expensive when it comes to administrative costs for establishing internal procedure, security measures, and staffing to keep your secret. The next question to consider is, will the invention be useful after 20 years? The answer to this question underlies the difference in terms of protection. The protection under a patent lasts for a maximum of 20 years, while a trade secret has no time limit. Trade secret will last as long as your agreement remains in place provided there are no breaches. On the other hand, after a patent expires, a competitor can legally use this information to produce a similar product without the permission of the patent owner. Therefore, being able to forecast the usefulness of your invention after 20 years is a good step in deciding how you would like to protect it. Another aspect is the principle of territoriality. Like other IP rights, both trade secret and patents are subject to the national law of the country in which they are protected. However, a patent only obtains its protected rights for a certain territory, where the title is granted even though the invention must be proved new and invented worldwide. Trade secret, meanwhile, is not subject to this grant procedure. All in all, patents and trade secrets are both powerful tools to protect your innovation in business. Whether a patent or trade secret might be more appropriate depends entirely on your invention, you, the inventor, and your company. Consultation with lawyer is highly recommended before coming to the final decisions. Hopefully this video clarified the basic differences between patent and trade secret, helps to answer some of your concerns, and contribute to the protection of you and your innovation. Thank you for your watching, and see you in our next video.